I did notices. I did not file my claims yet. I've been putting that off because I really don't want to have to file claims and ruin people's lives and ruin their jobs because they're not upholding my constitutional rights as a woman, not a defendant. I am a woman only. I, woman Angela. I, woman Angela. I, woman Angela. That's it.
Ms. Kristen, I got to tell you, I don't know what in the heck you're talking about. You're talking.
Put you down, you know, you're 19. Do something with your life. Don't become a statistic.
We are on the record in the 89th District Court for the County of Sheboygan. We're conducting the physical hearing upstairs in the circuit court rooms being clerked by the 89th District Court staff down in that courtroom. And we're here in the case of In re Beth Bridgeman on contempt matter. Counsel, you want to state your appearances, please?
Good morning, Your Honor. Paige Miller on behalf of the people.
Attorney Eric Villanueva appearing as a arraignment attorney on behalf of Beth Bridgeman.
Also, I will represent myself.
Yes,
okay.
we'll get to that.
I would like to say I'm here on special appearance. No, I think I have some rights here. I don't know.
What does special appearance mean to you?
It means in a common law that I'm a living soul. I am not the straw man of the all caps.
Ma'am, you'll have an opportunity at a later time. Please just take a seat.
I've never seen those opportunities come back around. Thank you. Okay.
We'll get to that in a moment.
So I am waiving
the time.
I am not waiving any of my rights.
Ma'am. Okay. Thank you.
Ms. Bridgeman, you're free to stand or sit, whichever you're more comfortable with.
I don't know how to pull the chair up, so thank you.
Well, then, if you want to sit there, I have no problem. Okay. All right, Judge. All right, well, Ms. Bridgeman, you're here for an arraignment on 2 allegations of contempt. So I have to advise you of what those are. The first was an order to show cause that I signed on December 13th, which alleges that you are in criminal contempt of court for the unauthorized practice of law and for preventing the defendant, Seth Flores, from meeting with the Michigan Indigent Defense Commission attorney prior to his arraignment. We scheduled that for a show cause hearing on December 20th. You did apparently appear in the courthouse that day and turned in a copy of the show cause cut into strips with the red lettering on it says your offer to contract is not accepted. And then you did not appear at that show cause hearing. So therefore I signed a warrant for your arrest for that non-appearance. So that warrant alleges that you are in criminal contempt for failing to appear at that show cause.
So
failing to appear for order to show cause on Wednesday, December 20th for preventing defendant Seth Miguel Thomas Flores from meeting with MIDC attorney prior to his arraignment. So those are the 2 contempt citations pending against you. You have the right to have a hearing on both of those allegations where your contempt would need to be proven beyond a reasonable doubt. So both those contempt citations, if you are found to be in contempt or you admit to being in contempt, you could be punished by up to 93 days in the county jail and or a fine of $7,500 or both. That's the fine. That's the maximum penalty for both of the contempt citations. Ms. Bridgeman, do you comprehend the rights that you have that I outline for you and the maximum penalties I outline for you?
I think that I would like to wait. I have a call into the state trooper that your office or the prosecutor's office called to investigate something with me. And I was on the phone with her and told her I had received the show cause, and she said, he can't serve a show cause. I shot over a copy of it. He can't serve a show cause because you're not under bond. This is from the state attorney general's office. I was still on the phone with her. I had filed the paperwork at 9 o'clock. She called me at approximately 10 o'clock. I was still on the phone with her till after 11 o'clock. And she told me that you could not issue a show cause because I was not under bond. Now I understand you have just precluded all of my common law rights by forcing me in the back door into your jurisdiction on this side of the court. And I know that this is not what was on the original document in its entirety. So you have amped up the charges. based on the fact that I failed to appear, but I believed she was going to let you know. She was collecting information from me for you.
Ma'am,
Okay, now,
just understand what the judge asked you regarding those two charges.
Did you just understand that I think there's a bigger overriding issue? Thank you.
Wait, hang on.
Thank
I'm
you.
not gonna have this,
I'm going to fire him, actually, so thank you very much, because I will represent myself.
okay. So you're telling me things in defense of the contempt citations, and you'll definitely have an opportunity to present any.
No, because you already,
Hang on, Mr. Villanueva, please stop. I don't want to have this be an argument between
Thank
you
you.
and Mr.
I guess I'd just like to, state that
well, I think we need to back it up.
pleading not guilty to both of those, and that she would like to request a hearing, that she would like to represent herself at that future hearing.
No, but all of my rights were strongly impinged upon for even when I never failed to appear.
Okay, we're gonna have a hearing where you.
She was working, okay,
Okay, you're gonna get your
Mr.
hearing.
Villanueva,
No,
I
this
direct you to
is-
stop
thank you.
arguing with Ms. Bridgeman.
Okay,
I mean, it's a pretty serious thing to have to spend the night in jail, to be brought in handcuffs and everything else, when I was not being belligerent in that regard. She told me that it was not an authorized show cause.
All right, if she told you that, she didn't have the authority to do so. But anyway, that's for the later hearing. So
Well, she was investigating. Okay.
Today's purpose is to advise you of the two contempt citations. So do you comprehend the maximum penalty that those could carry and the rights that you have that I outlined for you?
Now, can I ask, what statutes or what law or what are you saying here are the charges? Because this does not match, sorry, I have cotton mouth so bad. This does not match what the previous document was that you sent to me. And I have a picture of it on my phone, but my phone's not with me. Okay? It does not say,
I've told you the charges. I don't have to answer further questions about that from you. Do you understand the rights that I listed for you and the penalties?
why have they changed,
I'm
Judge
not
Becker?
answering that question.
Can the prosecutor?
No.
Why?
I need an answer to my question. Do you understand that? So you said you want to represent yourself, right? You wish to represent yourself and not have an attorney represent you?
Yes, I
Okay.
do.
If you want to do that, I must establish that you know what the penalties are and what your rights are. And I have to establish that you're not going to be disruptive to the court. If you refuse,
So are those,
then I'm going to appoint
not
an attorney for
refusing.
you. Okay, then I would appoint an attorney for you and you'd not be able to represent yourself.
I know, I listened to that with Trevor's case.
All right, so I'm asking you, and you saw what.
How can I be-
Ms. Bridgeman? So I first have to make sure you know what the maximum penalties are and what your rights are. Do you not?
Those maximal penalties are based on the charges, and I'm wondering how you arrived at a change in the charges.
I'm not answering that question. You know that you could face up to 93 days in jail and or a $7,500 fine. You understand it.
Up to that, okay, but I don't even understand what the charges are.
Okay. And do you have any questions for me about any of the rights that I listed, that you have to have an attorney and have a hearing and present evidence? Do you have any questions about any of those rights?
I have a whole question about the whole context of everything today, Judge Gaffier.
It's really quite simple. When you have an order to show up for court and you turn in a cut up piece of paper of it and say you're refusing to attend, that this is what happens next. That's pretty simple.
Oh, did that offend you?
No, it did not offend me. It was a contempt of court.
It's a
It's not
common law
about
thing.
anybody's personal feelings. It's about the authority of the court to compel appearances, and you did not appear. So I do believe, based on your answers, that you do understand the maximum penalties that you face and the rights that you have. All right, so we'll enter a not guilty plea on your behalf to both contempt citations. We'll schedule this for a hearing where the prosecutor will present evidence, and you can present evidence in your defense. If you want to have an officer come testify on your behalf, you can certainly do so.
I would like to request a trial by jury.
There is no right to trial by jury in contempt matter. So that request would be denied.
Okay, so then there's no chance to understand what you're charging me with prior to this hearing.
I've told you what you charge. I can read it again if you want.
I don't see where there's a code or a statute or any law that I have actually violated here.
Well, that's not required to be on a contempt citation. I've told you what the allegations are. If you want me to read them to you again, I will.
Okay, and the contempt charges that you're saying have changed from the first time.
No, there are two. One is the contempt for unauthorized practice of law and preventing Mr. Flores from meeting with his MIDC attorney prior to his arraignment. The second one is for failing to appear for the show cause hearing on that contempt.
So I only show one now.
What one do you have?
And this is preventing. And how did you arrive at this at a later date than to issue a bench warrant?
Mr. Villanueva?
There's two items check marked here.
This is after the fact. So then you added a different charge than the previous one about the same date.
Ma'am, he read two charges. There's two charges marked here.
Excuse me. I probably have more degrees than you do, okay?
All right.
Now,
I'm going to find that
please, Judge Gothier.
sure, go ahead.
Thank you. Okay. So the first one was that I was practicing law. That was the first one. That's the show cause that you say I failed to appear for.
No, it was contempt for unauthorized practice of law and preventing defendant Flores from meeting with MIDC attorney prior to his arraignment. That was on the original.
No, I have a picture of the original one. This is why I'm not sure.
Do you have a copy of that show cause in front of you right now or no?
This one.
Would Your Honor like to see what she has here?
I just.
Okay, so how do I defend?
Hang on. If you do not have in front of you right now a copy of the first show cause, I'm happy to provide a copy.
So how did you arrive at a second show cause?
Because you didn't show up. The second show cause is for failing.
But I wasn't on bond. So both show causes are not in effect because I'm not on bond.
Your Honor, what is the date of the first show cause?
December 20th. Oh, sorry, that was before the December 20th.
Sorry. You may view this document. This is out of the court file. You may view it and then.
So, Judge Gothier, do I have any other recourse to clarify where I was on that day and the information that I was going off of by your own investigator?
You do. You do.
Okay.
That is a hearing date. Today, we're going to schedule a hearing date, and you can present that evidence at that time.
And how will the hearing affect a trial by jury?
As I told you, there is no right to trial by jury
For a contempt charge.
So
Oh, so this is a perfect, nice little tidy package for everything. I see. Okay.
So I can schedule this for a contempt hearing on Thursday, January 11th at 2 p.m.
I think that would be way too soon for me. Thank you.
Why is that?
I need to get to some of the documentation and follow up with that state trooper, as well as perhaps a few other people, because I'm guessing, am I supposed to just talk to the prosecutor without the other witnesses that I had in my presence at the same time?
I could schedule this for the afternoon of Thursday, January 25th, then. That gives you 3 weeks.
Thank you.
So we'll schedule this for a contempt hearing on both allegations of contempt on Thursday, January 25th at 2 p.m. And do I understand correctly, you do not wish me to appoint an attorney that you want to represent yourself?
And then who makes the decision? You make the total decision then?
Well, no, first you make the decision whether you want to represent yourself. As long as I'm convinced that you're doing so of your own free choice, that you understand what's going on, and that you're not going to be unduly disruptive, then you'll represent yourself.
So what am I allowed to do at the hearing to defend myself appropriately?
You're allowed to present legal arguments. You're allowed to present witnesses to testify under oath, yourself or any other witnesses that you bring with you. If you want to subpoena a witness, if you're representing yourself, you can't issue a subpoena without the court's signature. An attorney can issue a subpoena on their own.
So I
If you want
can't
to subpoena somebody, what you would do is you'd go to the court clerk, they give you the paperwork, you'd fill out the subpoena. They would give it to me to review, and if it looks like it's reasonably, connected or relevant to the case, I would sign the subpoena, and it would be given back to you for you to serve upon the person to compel their appearance.
I did not even get to watch the video that day because I was still on the phone with the trooper. And then people told me after I went up for Christmas that there was maybe a bench warrant, that you had issued a bench warrant. But everybody looked for it online at VineLink and couldn't find any bench warrant. So I was not trying to. I thought that trooper had told you what she told me, that I wasn't on bond, so I couldn't have a show cause.
Okay, well, that's all going to be sorted out at the hearing. Okay, we don't have to sort all that out.
Oh, that's a lot of overnight in being arrested downtown and everything for a misunderstanding that I would like to,
Ms. Bridgeman, I mean.
okay, I get it, Judge Gothier, I know what happened.
You're not fooling me. I've got the show cause that you apparently cut up into little strips and wrote.
Yeah, but I brought it at 9:00 because do you know that that's actually a common law practice? And there are courts that recognize common law because sovereign people and people who take an oath of office can follow common law.
All right, so the
Not the codes and statutes.
Is scheduled for Thursday, January 25th at 2 p.m. I find that Ms. Bridgeman is unequivocally exercising her right to represent herself, that she understands the nature of the charges against her, the maximum penalty, and the rights that she has. I find that although she certainly disagrees with the court procedures and processes, which is her right, that she's not being unduly disruptive to the court's business. So the court's going to recognize Ms. Bridgeman's right to represent herself at that hearing.
Can I ask one question? What are the parameters that you're going to decide is practicing law versus helping somebody maintain their unalienable rights? How would I delineate that in defense of myself?
Well, that's a question of that's a question of law that you can research before that day. And I said I'll entertain legal arguments. The prosecutor will have to prove beyond a reasonable doubt at that hearing that you did in fact practice law on that day. That's where then there's a risk to representing yourself, because an attorney, has access to and better training in researching the case law, interpreting what that is. The Michigan Supreme Court has issued some opinions about what that is. If you're representing yourself, you're going to have to find those on your own and make the argument as you see fit. If you want to hire an attorney, or if you want an appointed attorney, they would be able to fashion those arguments on your behalf. But I'm not going to. No,
I've been down that path before, and it never turns out the way they first present themselves to you, that they're going to fight the case. It never turns out that way. So I'm fully cognizant and aware of that, but I wanted to see what your stand.
You're on the charges. I'm going to recognize that you are exercising your right to represent yourself and discharge Mr. Villanueva from any further responsibility in the matter. The only other question I have to decide is whether you should be released on your own recognizance, or whether you should be required to post a bond before the next hearing. So I'm going to hear first from the prosecutor and then from you on that question. Ms. Miller?
Your Honor, I would object to a PR bond in this case, first because of her failure to appear on December 20th. She had notice of that hearing date as she dropped off the show cause to the court that had the date on it. Further, an underlying case that this was initially filed, she encouraged someone to not appear for their court date or to leave the court before they were arraigned. So I do have concern about her appearance at the next trial, the next date.
All right, Ms. Bridgeman, anything you want to tell me with regard to whether I should allow you to be released on your own recognizance before that hearing, or whether...
I showed up at 9 a.m., Your Honor, and anybody could call me if they didn't understand that. I filed a similar document in Mackinac County and they accepted it. Common law is a very acceptable kind of a standard if you know it and you know what you're doing. So maybe there'll be a chance that I can present some of these other avenues, because how does my country tell me to take an oath of office to defend the Constitution, but then I'm held to only codes and statutes of the Michigan legislative body, governor, and perhaps Supreme Court? That's the overarching question here, I think. And I think a lot of people
Well, I can
struggle with
recommend the
that.
Schoolhouse Rock video to you about how a bill becomes law and the laws.
Oh, I know how it happens.
Your Honor.
I also know we don't have a lot of judicial review.
So,
Your Honor,
that's
part of
one
the-
question, any input, Mr. Gilman?
Yes, I guess, I know you just released me as the attorney of record, but I guess in support of the bond on her behalf, would
Yes, go ahead.
Yeah, so I like to advise the court that Ms. Bridgeman is a resident of the city of Sheboygan. She advised that she's a former social studies teacher. She's presently collecting disability, so she informs me. I'm unaware of the status of if she has an automobile or anything. I'm not aware of any known criminal history for Ms. Bridgeman, and she reports that there's no drug or alcohol issues. Granted, there's this allegation of not appearing at a previous hearing, and she was picked up, I believe, within the Sheboygan County for that. And so I advise that Your Honor, and one last thing, she's a politically active member in the community. She has audited an election previously. So I believe, she's more or less, I guess, committed to this area, this local municipality. It seems unlikely that she would go anywhere, and how she would do that. And so, Your Honor, I would ask that you set reasonable bond for her release.
Thank you.
All right, thank you. Well, I don't believe that Ms. Bridgeman poses any danger to public safety. I don't think she's a flight risk per se of fleeing from the jurisdiction. However, I do believe that she's a heightened risk of just flat out refusing to appear, as evidenced by the fact that she cut up the previous show cause into little strips and wrote that she wasn't accepting an offer.
Well, they
It wasn't
didn't,
an offer, it was an order
sorry,
to appear.
they didn't actually hand it to
People just
me.
refuse to appear on orders to appear by saying, sorry, I don't want to. So I don't think that release on her own recognizance would be sufficient to secure her appearance. So I'm going to set bond in the contempt matter at $10,000 cash or surety at the full amount. There'll be no special conditions attached to it, however, just the standard conditions, Ms. Bridgeman, that you have to make sure that we know. If you change we have to know your address, contact information. You can't violate any laws in the state of Michigan or any political subdivision thereof, and you must appear for all court appearances.
So the whole bond thing keeps me under your jurisdiction, which I wouldn't have come into your court the same way today, except that you put me in jail, so I was forced to.
That's the bond that I've set. So
This is the struggle between keeping my oath to defend the Constitution and adhering.
I've taken a similar oath, and I believe I'm going to do today, Ms. Bridgeman. So we'll see you on the 25th.
We will look at the case.
That's what. All right, adjourned.
She's only up here from North Carolina.
All right, good morning. We are back on the record in the 53rd Circuit Court for the County of Presque Isle. Our next case on the docket is People of the State of Michigan versus Angela Marie Christensen. It's file 21-93185FH. We have Ms. Christensen attending by Zoom, representing herself, and the prosecuting attorney, Mr. Radzaban, is here in the courtroom. We are providing public access both in the courtroom and online. And Ms. Christensen, although you're appearing from your home, for convenience sake, it might not feel like a court hearing, but it is a court hearing, so I'm going to ask you to please remove your hat.
Oh, sorry.
No worries. Okay, thank you. All right, so as we begin the hearing, just like last time, I'm required each time to remind you that you do have the right to the assistance of a lawyer if you wish. And that includes the right to a lawyer at public expense if you were indigent, and that you've previously waived that right and wish to represent yourself. And so I guess I want to ask you again, do you reaffirm that you'd like to represent yourself in this matter, or would you like to have a lawyer?
No, I would like to self-govern, and I stand on my paperwork.
Okay, so what we have today, you did file 4 written notices that asked for some type of relief, and we had adjourned the hearing to today for any argument on that. so the prosecutor has had a chance to review them. So, Ms. Christensen, you say that you stand by the paperwork, and that's fine. I do have the paperwork in front of me. Is there any argument that you'd want to make on your behalf right now to me in support of those claims, or do you wish to just rely on the written pleadings you filed?
It is my wish to stand on my paperwork.
Okay. Mr. Radsbaum, do the people have any argument in opposition to those 4 notices?
Your Honor, I've reviewed the paperwork, and I guess while she may not recognize or honor the state of the law, I don't believe that there's any relief that's recognized under law that would allow you to dismiss this case against her based on what she's alleged in the paperwork. I fail to see it.
Okay. All right. Well, Ms. Christensen, now I'm going to make a ruling on the notices, which I'm construing as some motion or request for relief. And I've got a written order that I'll enter. I'll read it at this point. Defendant, who at this point in the case is representing herself, has filed 4 handwritten notices. These notices appear to seek relief in one form or another. As to the first notice, defendant asserts that she is a woman and not a defendant. The court finds that Angela Christensen is both a woman and a defendant in this criminal action. To the extent her notice seeks relief, such relief is denied. As to the second notice, defendant demands that any man or woman with a claim against her appear and present such claim in open court. To the extent that this notice seeks to invoke defendant's right to confront her accusers, this court will enforce that right. However, the right of confrontation does not require the complaining witnesses to appear at all pretrial hearings, but only the trial or any necessary evidentiary hearings. So to the extent that this notice seeks to require the appearance of any complaining witnesses at all pretrial hearings, such relief is denied. As to the third notice, defendant asserts that this court lacks authority over her and that only her creator has that authority. Without gainsaying the authority of the creator, it can be noted that religious traditions commonly recognize that the creator has instituted human authority as well. In this matter, the people of the state of Michigan, through ratifying the 1963 state constitution, as well as its predecessor constitutions, have established this court and its authority. The people of the state of Michigan, through their elected representatives, have established laws that apply in this court. And the people of this county have elected this judge to serve in this office. And this court has subject matter over this felony prosecution and has personal jurisdiction over this defendant. Any relief sought by this notice is denied. As to the fourth notice, defendant claims that this court and the government exist only because she allows them to exist. To the extent that this assertion reiterates the proposition that our constitutional republic is founded on the consent of the governed, such proposition is axiomatic as a general matter. However, this proposition does not require that the government must obtain consent or permission from each individual person before exerting governmental authority over that person. Such an idea is nonsense and would result not in a constitutional republic, but in anarchy. This defendant's views would render all the criminal laws null and void, which is legally and practically absurd. Therefore, any relief sought by this notice is also denied. All right, so Ms. Christensen, all of the claims and papers that you have filed, I have found to be lacking in legal and factual merit, and I have denied any such relief. And I'm entering a
That's fine. Please stop referring to me as a defendant. And I guess the next step will be, I guess I got to do the actual filing of the claims if you're going to deny all of those.
No, I don't know what claims you're talking about. You filed some claims or notices or requests.
No, I did not even file my claims yet. I did notices. I did not file my claims yet. I've been putting that off because I really don't want to have to file claims and ruin people's lives and ruin their jobs because they're not upholding my constitutional rights as a woman, not a defendant. I am a woman only. I, woman Angela. I, woman Angela. I, woman Angela. That's it. Not defendant. I'm not a defendant.
Well, you are. And
Okay, in your opinion and legalese, yes, but I am a woman. So do we need to do trial by jury when we can do my claims and file my court with your court at the same time? Because that's going to be my next step, to file claims against everybody involved in this case. Because there is no verified claim, and complaints and claims are two different things. I don't want to file claims. I'm trying very hard, and I've been trying hard to not do that. But I guess if we got to keep going, that's my next step. And I will file proper claims with the proper people and the insurancing for the bonding. So I don't know what you want to do at this point. I really don't want to have to do that.
Ms. Kristen, I got to tell you, I don't know what in the heck you're talking about. You're talking nonsense. So here's the thing. I am not going to relinquish my authority in this case. I'm not. All right. The prosecutor's office can dismiss the case. They're choosing not to. So that means we do have to go forward to a jury trial unless you want to plead guilty. All right. But what I'm also going to do is your ramblings here today and at previous hearings, and after I reviewed your written notices, it's clear to me that you have no concept of the legal and factual issues at stake. And
I would never know anything about legalese because I never went to school to do the legalese, so I don't understand that part.
All right, you're illustrating my next point, and you have no respect for the authority of the court. You continue to interrupt me and such, and file these nonsense claims. So I am hereby withdrawing my consent for you to represent yourself. I'm referring this matter to the Office of Assigned Counsel for appointment. So any papers you file in this case, I will reject because they have to be filed.
Well, I don't accept that offer, and I do not require you to give me any court-appointed attorney, and I will self-govern because that is my right. I don't want an attorney. I don't do legalese. I'm sorry. I'm not trying to be rude or disrespectful. I'm trying to be very decent.
Well,
I stand on my paperwork and I'll do the rest of my paperwork. I will keep doing it, and now I'm going to file my claims, so that's fine. But no, I don't need no legal counsel. I refuse that offer. I do not accept that offer. I'm sorry. With all due respect to you, I don't accept that.
well, Ms. Christensen, it wasn't an offer. So we are scheduling this next for a docket call on February 14th at 10:30 in the morning. And I'll refer it to the Office of Assigned Counsel for you to have an attorney at that hearing. You are no longer allowed to represent yourself in this matter, and you will be in person in my courtroom at that date and time.
I'm sorry, but I cannot be there. I can do it via Zoom, and I don't accept that offer either unless you want to compensate me for my gas and my time, because I can't do that. I can't even afford to. Sorry.
Ms. Christensen, it's not an offer. I want to have you here because you've expressed such disregard for the proceedings. I want to have you here so you can see your attorney. Ms. Christensen, stop interrupting me. It's not an offer. You will be here, or I will issue a warrant for your arrest if you refuse to attend in person. All right, we'll see you February 14th, or I'll issue a warrant for your arrest.